Hello, my name is Denise María Díaz de Gocera. Today we go to present ruins get 265 art 2024 issued by the Constitution concerning Mr. Marta Cecilia Barahona Álvarez again consent. The case arose because Marta Cecilia were for consent and Lenden Zipaquirá, but the company decided to share her de Bogotá. This transfer recovered approximately 6 hours on the community, increased air transportation expenses, and reduced the amount of Thai chicken expected within to my children. In the exchange, she was that single mother and the midst on the one from her house and the situation even had emotional difficulties from her youngest child. For the reason, she the causes to work si pakira, kiat, or kahikam, or to perform her through telework. The center issued under proved was to determine where the council opposite exceptions issues were indicted, remanded, and forged power to modify center working can the job. Thank you.
Council opposite the employer's request, the company argued that the transfer was part of this management authority that sits that used variandi. It also stated that there were no violable position in Zipaquirá, Shia, or Cajica, and that teleworking was not appropriate due to the confidential nature of her duties. Marta Cecilia filed a tutela action seeking to protect, among other things, her right to work under dignified and fair conditions, her minimum means of subsistence, and her right to a family life. Wherever the judge of first instances denied the tutela because he considered that there were other legal machines available through the lower courts and that an irreparable harm had not been demonstrated. The employee appealed the decision, but the judge of second instance upheld the denial. Therefore, this case was sent to the Constitutional Court for review.
The court analysis was reviewing the case. The Constitutional Court found that Marta Cecilia's situation was particularly vulnerable. The court took into account that she was a single mother, had two minor children, that her salary was essential for supporting her household, and that the transfer involved in high expenses had affected her family life. The court emphasized that use variety is not an absolute power. Employer may modify certain working conditions, but must do so in reasonable and proportionate manner while respecting the employer's fundamental rights. Telework as also considered. The court found that counsel had not sufficient demonstrated the confidentiality the information prevent this working arrangement, especially because the company had previously allowed the employee to work from home on some occasions. For this reason, the court concluded that counsel at exercise is used variandi in Ursenberg, I arbit and made.
Afternoon, and to conclude, the Constitutional Court finally set aside the previous decisions and temporarily granted protection of the right to work in dignified and fair conditions. The court ordered Comkel to reach an agreement with the worker on the most suitable place to perform her duties, considering Zipaquirá, Chia, or Kajika as options. If there was no position available in any of those locations, the company had to allow her to perform her duties through telework from home. The court also ordered the company to prevent any possible act of labor retaliation against the worker. The decision included a partial dissenting opinion from Justice Jorge Enrique Ibáñez Nájar. He agreed that the workers should be protected, but considered